If you're watching this video, you most likely have reviewed our sample motion online to ask the court to limit cumulative testimony from the defendant's experts. And this is a common problem we have in any of our large personal injury cases, but it's a particularly significant problem in medical malpractice cases, where, because the defense doctors are often well credentialed, the defense lawyers want to bring in multiple doctors to say the exact same thing from the exact same perspective. And they do this because it works, because the ganging up effect does give them some currency. It allows them to say the same thing twice, which sort of has an echo chamber of we must be right. And it also gives the jury different experts from a personality standpoint. It gives multiple shots at getting an expert who connects with one of the jurors. So it's of critical importance to make sure we're reaching out to the court and saying, you're more than welcome to present this testimony, but you can't present it cumulatively, and you can't have two experts saying fundamentally the exact same thing. Ultimately, on this issue, in Maryland and in most jurisdictions, the court is going to give a lot of latitude, or the appellate courts are going to give a lot of latitude to the trial judge in making that determination. But there are a number of Maryland appellate opinions on point where the trial judge has limited cumulative testimony, and the appellate courts have approved their decision to limit it using the abuse of discretion standard, which is very broad and obviously, again, very deferential to the trial courts. But there's no question that plaintiffs' lawyers need to get out in front of this issue to make sure they're not facing duplicative testimony. The other problem I should point out too, it's a corollary to this issue, is when the defendants have named so many different experts and you have no idea who they're going to call at trial. So maybe they're not going to use cumulative evidence at all, but you don't know which of the 10 experts they're going to call. And I think most courts are receptive when you reach out and say, hey, we want to know, they can call whoever they like, but we want to know who they intend to call at trial. Because many times they schedule these witnesses and put them on as prospective experts, and they've already decided internally they're not going to call that witness. And in fairness to everybody, they should disclose that, and I think, again, trial courts are pretty receptive to doing that.